So Richard, there was a landmark decision passed down in October of 21 and it related to racial discrimination in the workplace. Could you tell us a little bit about that particular case and what happened there?
Yeah, thanks Annie. So that was the case of Mr Ferguson, who was our client, and the decision was handed down by the Federal Circuit and Family Court of Australia. It was an interesting case because the facts were such that Mr Ferguson was employed as a concrete agitator driver. In the workplace, unfortunately, he was subject to what I would call quite severe forms of racial vilification based on his race and skin colour. And they were to the effect that on a day-to-day basis, both his manager and fellow employees would say to him things like, "You are a black cunt," or would refer to his race or his nationality, such as him being a New Zealander, and saying that either he or those of his race were all thieves or dole bludgers. So, simple case, those were the facts, and that was the subject matter of which the Federal Circuit Court had to make a decision about, and whether or not that constituted racial discrimination.
Yeah, thanks very much. So can you tell us what the applicable laws were in that case?
Absolutely. So the case was moved under the Racial Discrimination Act 1975, which is quite a heralded bit of legislation in this country. Particularly in that Act, there are two sections that apply to Mr Ferguson's case. One was Section 9 and the other was Section 18, capital C. 18C, of course, is a bit more of a controversial section, but in summary, both of those sections have the effect that where there are, let's say, comments of a racial vilification nature in the workplace, that Act and those particular sections prohibit such acts and particularly prohibit other workers or other employees from racially vilificating other employees on the basis of either their race, their skin colour, or other cultural attributes.
So you've talked a little bit about the facts. Can you tell us how the judge actually decided that case at the end?
Sure. It's an interesting case because comments such as black cunt, which is a very derisive comment, is one where generally the parties accepted that if that comment was made, it would have been a contravention of particularly Section 9 of the Racial Discrimination Act. Other comments that were made in the case, for example, sheepshagger, were a bit more controversial, and the judge had to, I guess, make some decisions about whether that particular comment could be considered racial in nature. But in summary, because of the, I suppose, nature of the comments made, this was entirely an application that was decided on the credit of the parties and a material finding of fact that the judge had to assess witnesses. So in this particular case, Mr Ferguson had his version of events, and the other employees and managers who were the individuals who are said to have contravened the Act, particularly Mr Pendergast and Mr Webb, had a different version of events, which in summary was a complete denial of what happened. So his Honour Judge Driver had to review the facts and ascertain who was telling the truth and who wasn't.
So credibility is very important then, isn't it, Richard?
Absolutely. In a case, or in a vast majority of cases of this nature, you often have a positive allegation, so a material fact that you need to prove, and you often have an employer or a group of employees who are employed who disagree and deny the allegations. Ultimately, a decision maker, which in this case was a judicial member of the Federal Circuit and Family Court of Australia, has to make a decision about simply who's telling the truth on the balance of probabilities, who's to be believed.
So what was the final outcome of that case? What did the judge decide? Tell us a bit about that.
Sure. So ultimately, amongst other matters, His Honour found that Mr Ferguson was a witness of truth. What Mr Ferguson had to say about the various comments, such as being referred to as a black cunt, was found to be correct and a material fact that was proven. On that basis, Mr Ferguson was successful. Now, aside from the monetary compensation, which in this case was $50,000 as general damages, what's interesting is in this case, Mr Driver also ordered both the employer and the individuals to provide a written apology for the racial discrimination.
Wow, okay. So what advice would you give to someone like Mr Ferguson who's experiencing racial discrimination in the workplace?
Sure. Look, as a legal practitioner, we can't put ourselves in the shoes of the client ultimately. And as His Honour found in this particular case, being subject to such vile forms of racism would no doubt have a severe impact on someone's health and, of course, their ability to be able to function in the sense of their mental health.
Definitely.
And, I mean, that was encapsulated by the words of His Honour, which said that my client was entitled to significant damages, which were assessed at $50,000. So definitely from a legal practitioner's point of view, when you look at a case like this, it all came down to credit and evidence. My advice, if you are subject to these forms of vile abuse in the workplace, document it. Make sure you have file notes, diary notes. Make sure you speak to someone about it. And if you are going through some pain and suffering and humiliation, which no doubt a lot of employees who are subject to this type of abuse are, seek relevant medical advice. Because even by seeking that medical advice, that in turn will actually be evidence in your matter if it goes as far as litigation in a court.
Yeah, very interesting. Thanks very much, Richard, for that.
No worries. Pleasure, Andy.